My name is Susan Collins and I'm an associate at Thackray Williams. Alongside me is my colleague Sibel Vurdu, also an associate here at the firm. We're both delighted to be here with you today discussing something that can be both exciting and, let's be honest, a little bit intimidating for many new business owners: signing a commercial lease. We understand that taking the step to lease commercial property for the first time is a major milestone for your business. Whether you're opening a cafe, starting a retail store, or setting up any other sort of business, it's a huge commitment that can feel overwhelming. But it's also a really important one. The lease you sign will not only define the property where your business will operate, but it will also impact your business's financial future, flexibility, and day-to-day operations. We've personally seen firsthand how easy it is for first-time tenants to feel unsure or even caught off guard by certain clauses or terms in a lease agreement. That's why it's so important to fully understand the terms and conditions before you sign on the dotted line. A well-negotiated lease can set you up for long-term success, while overlooking key details could lead to costly consequences down the line. Today, we're going to walk you through the top 10 tips you need to consider before you sign your lease. Our goal is to help you feel more confident in your lease negotiations and ensure you're in the best position possible as you embark on this exciting new venture. We'll be covering everything from rent-free periods to understanding your repairing obligations, break clauses, and the often overlooked costs that come with leasing a commercial property. By the end of the session, we hope you'll have a much clearer idea of what to look out for and how to protect your business interests in the long term, and we're happy to take questions. As Linda said, if you could kindly try and keep the questions to the end, that would be really helpful. With that said, let's dive straight into rent-free periods. An important element to negotiate when signing a commercial lease is a rent-free period. Essentially, this is a grace period where you don't have to pay rent, allowing you the time to focus on fitting out the property and getting your business up and running without the financial strain of paying rent immediately. For many first-time tenants, the process of setting up a business can be time-consuming and costly. Whatever your business, you may need time to carry out essential fit-out works or renovations to make the property suitable for your operation. For instance, if you're planning on opening a cafe, you'll likely need to make alterations to the kitchen area, install appropriate shelving, and install kitchen equipment. These changes can be expensive and take time. Requesting a rent-free period ensures you don't begin paying rent until the property is ready for business and you have begun operating. This can be especially beneficial during the early days when cash flow is often tight and you're still establishing your customer base. So, how long should you ask for? Generally, asking for at least 3 to 6 months rent-free period is a good starting point. The length of this rent-free period can vary depending on factors like the size of the property, the scope of the work needed, and the current market conditions. For example, if the property is in a high-demand location or is in an area that's particularly desirable, like a prime city centre or busy high street, landlords might be more reluctant to offer a lengthy rent-free period. If you're a new business with limited trading history or a financial track record, this is known as lower covenant strength. The landlord might offer a shorter rent-free period as a compromise. However, even if you're a startup, don't be discouraged. It's always worth negotiating for the best possible deal. Negotiating a rent-free period is a standard part of the commercial lease process, and it's in your best interest to ensure that the time you're granted aligns with your business needs. It gives you a solid foundation to invest in your business's growth without immediate financial pressure. However, be mindful that landlords may offer different rent-free periods based on their own circumstances, such as the length of the lease term, market conditions, and the strength of your business proposal. Our top tip: always ask for a rent-free period of at least a few months, especially if you need to carry out significant works. Be prepared to negotiate. With careful planning and negotiation, this rent-free period can have a significant impact on your cash flow and allow you to get your business off the ground with more ease. Then we pivot on to the next aspect, which is understanding your repairing liabilities. Understanding your repairing liabilities is one of the most critical aspects of entering into a commercial lease, and one that many first-time tenants underestimate. These liabilities determine what you're legally required to repair, maintain, or reinstate during the term of the lease and upon its expiry. Tenants are typically required to keep the property in good and substantial repair and condition. This sounds straightforward, but in legal terms, it can mean you could be expected to return the property in a better state than when you received it. even if it was already in poor condition when you took possession. For example, if the property had worn out flooring, old wiring, or water damage from a pre-existing roof leak, the default lease wording could still make you responsible for rectifying these issues. This is where a schedule of condition becomes essential. A schedule of condition is a detailed report, often including photographs, that captures the state of the property at the time the lease is entered into. It can be used to limit your liability by specifying in the lease that your obligation is to maintain the property only in the condition shown in the schedule, rather than putting it in a better state than it was in originally. This schedule will be attached to the lease as evidence of the condition. Let's say, for example, you take a unit in an older building, and it's in poor condition with damp issues in certain areas. Without a schedule of condition, your lease might require you to repair those defects at your own cost, even if you had nothing to do with causing them. With a schedule of condition in place, you can protect yourself from being held liable for these pre-existing issues. This matters most when a lease ends. Landlords often serve a schedule of dilapidations. This is a formal list of repairs that they claim the tenant is required to rectify prior to leaving the property. If a lease doesn't properly limit your repairing obligations, you could face unexpected and often significant costs to bring the property up to a standard that goes beyond how it was when you moved in. These costs can include repairing structural elements like roofs and windows, repairing wall flooring or outdated fixtures, redecorating the entire unit, even if it wasn't pristine when you moved in. Our tip: when negotiating the lease, insist on the inclusion of a schedule of condition and a clause that clearly limits your repairing obligations, so you are only required to maintain the property in no better condition than as shown in that schedule. You should also consider having a survey of the property, where a building surveyor assesses the property and provides a report on the condition. This can help uncover any hidden issues that you may inherit repairing liability for and give you leverage in negotiations. Key questions to ask: am I expected to return the property in a better condition than when I took it on? Will the lease include a schedule of condition? Are my repairing obligations clearly defined or open to interpretation? Understanding and limiting your repairing liabilities can save you thousands of pounds at the end of your lease and give you peace of mind throughout the term. Third up is right to renew and security of tenure. An important protection for business tenants is the statutory right to renew the lease at the end of the contractual term. This protection is granted under the Landlord and Tenant Act 1954 and is commonly referred to as security of tenure. Security of tenure means that once your lease comes to an end, you cannot simply be evicted. You have the legal right to request a new lease on broadly similar terms. The landlord can only refuse this request on certain limited statutory grounds. The right gives business tenants long-term stability and protects the value of any investment you've made at the property. The landlord's agent is unlikely to explain what this means, so by having awareness, you are able to protect yourself in the early stages of the negotiations. Let's take a practical example. Suppose you're opening a restaurant and sign a 5-year lease. During that time, you invest heavily in expensive kitchen equipment, branding, local marketing, and build a key customer base. If your lease doesn't have security of tenure, your landlord could simply refuse to grant a new lease when the term comes to an end, effectively putting you out of business unless you find a new location and start from scratch. This can be especially devastating if your business is location sensitive, such as in retail, hospitality, or food service. Some landlords will try and exclude this statutory protection from the lease entirely. This is known as contracting out of the Landlord and Tenant Act 1954. Our tip: be extremely cautious if you're asked to accept a lease that's contracted out. Make sure that it aligns with your business plans, particularly if you're investing significant time or capital into the property. If a lease is contracted out, you'll have no right to renew it, and the landlord can refuse to re-let the property to you for any reason when the lease ends. It's also important to note that even with security of tenure, landlords can oppose your request to renew, but only on one of 7 specific legal grounds, and your solicitor can advise you on whether these apply. Key questions to ask: does my lease include or exclude security of tenure under the 1954 Act? Does excluding this protection align with my business's long-term plans? In summary, security of tenure is one of the most powerful rights you can have as a business tenant. Always seek legal advice before agreeing to contract out of these rights and understand the risks of not having renewal protection. Moving on to annual rent, insurance rent and service charges. When entering into a commercial lease, it's absolutely essential to understand the total cost of occupation, not just the annual rent figure quoted by the landlord or their agent. The annual rent is just one part of the overall financial commitment. Additional charges such as insurance rent, service charges and VAT can significantly increase your monthly, quarterly and annual costs, especially if they're not properly anticipated. Annual rent is the agreed sum you pay the landlord for occupying the property. It's usually paid quarterly in advance and will be one of your largest fixed costs. However, it's important to understand that your real liability extends beyond this figure. Under a full repairing and insuring lease, tenants are responsible for all repairs and maintenance of the property, as well as the cost of insuring it. For example, insurance rent is the amount you pay towards the landlord's cost of insuring the building itself. It doesn't cover your own business contents or equipment. The landlord will usually take out a comprehensive building insurance policy and recover the premium, either fully or in part, from the tenants. This charge can be a fixed percentage or a fair or reasonable proportion, depending on what's stated in the lease. This is common in multi-let buildings. The amount can vary each year, and it's vital that your lease clearly sets out what type of insurance you're contributing to, defines what's covered, such as structure, flood, fire, terrorism, and confirms whether you're paying a fair proportion. Service charges are another common cost, especially in shared buildings or developments. These charges cover the upkeep of common areas such as lobbies, stairwells, gardens, car parks, structures and external maintenance. They can include cleaning, landscaping, lighting, security and management fees. Your solicitor will take instructions on whether the services listed in the lease are all required, and they will raise additional inquiries with the landlord solicitors, which will reveal important information, such as whether there are planned or upcoming major works which you could become liable for. Depending on the landlord and the building, service charges can be unpredictable and occasionally excessive. For example, if the landlord decides to undertake major repairs or refurbishments in the building, these costs may be passed on to you through the service charge, even if the work doesn't directly benefit your property. Our tip: try and negotiate a cap on the annual service charge, or at least request a detailed budget in advance. Make sure the lease includes, includes clear definitions of what the service charge covers to avoid being billed for unreasonable items. Also check whether the landlord is charging VAT on top of the annual rent and service charges. Some commercial rents are opted to tax, meaning the landlord has elected to charge VAT, currently 20%, on the annual rent or service charge. This can make a big difference to your budgeting, especially if you're not VAT registered and can't reclaim it. Our further tip: always confirm whether VAT applies to the annual rent, service charges or insurance contributions, and whether it's included in the quoted figures or added on top. Your accountant or tax advisor can help assess how this impacts your cash flow. In summary, understanding your full rental liability, including insurance, service charges and VAT, is key to avoiding budget shocks. Ask for full transparency in your lease and request breakdowns or sample budgets from the landlord wherever possible. Don't just focus on the annual rent, focus on the whole financial commitment. Lastly, I'll be covering break clauses and the flexibility to end early. A break clause is an important term you can negotiate in your commercial lease, especially if you're a new business. It gives you the right to terminate the lease early, usually on a specified date or within a certain window, without incurring the full liability of the remaining lease term. This flexibility can be invaluable if your circumstances change. For example, your business might grow faster than expected and you might need a large property. Sales may fall short of projections and you might need to reduce overheads. A better location might become available, or market conditions such as a recession or pandemic might make your current lease unsustainable. Without a break clause, you're legally bound to continue paying rent and meeting all obligations for the duration of the term, regardless of how well or poorly your business performs. Break clauses can be tenant only, where the tenant has the exclusive right to break, mutual, so either party can break the lease, landlord only, so the landlord has the exclusive right to break. They can also be conditional, requiring you to meet specific conditions before you can validly exercise the break. Tip: when negotiating a break clause, consider whether you require a tenant-only break clause that is as early as possible, typically after 2 or 3 years of a 5-year lease, and consider whether you require more than one potential break date. Make sure the break clause conditions are RICS code compliant. This means it should be reasonable and not include disproportionate or vague conditions that could invalidate the right to break the lease. If this is not set out clearly in the heads of terms, this can delay the transaction. Your solicitor may need to spend time negotiating the terms on which the break clause can be validly triggered. Common pitfalls include requiring that all payments be made up to date, which may include minor disputed sums, requiring full compliance with all lease obligations, some of which may be subjective or open to interpretation, not giving significant notice or missing a procedural requirement, such as serving the break notice on the wrong party. Even a minor technical breach, like failing to repaint a wall or being late on a single service charge payment, could invalidate the break clause, leaving you trapped in the lease for years to come. Tip: ask for the break clause to be unconditional or subject only to essential objective criteria, such as giving proper notice and being up to date with annual rent, but excluding service charges or minor sums. If conditions are included, make sure they're clear, reasonable, and achievable. It's also essential to get legal advice. Many tenants lose their break rights due to small avoidable errors in how the notice is served or because conditions are not fully met. In summary, a well-drafted break clause is a vital safety net. It gives your business room to grow, adapt, or exit without being locked into a long-term, potentially unworkable financial commitment. Insist on a fair break clause and don't be afraid to walk away from a lease that refuses to offer one. We've now reached the end of my portion of the webinar, and I'm passing over to Sibel to take on with permitted use and planning considerations.
Thank you, Susan. A really useful insight on those 5 core areas. As Susan mentioned, I will be moving on to permitted use and planning considerations. So there are 2 key considerations when it comes to using commercial property. Firstly, what is permitted under the lease terms, and secondly, what is permitted by planning laws. Even if the lease permits a particular use, such as operating as a restaurant, you will still need to ensure that the correct planning use class is in place as granted by your local authority. The lease and planning permission must align. Having one without the other is not sufficient. Operating outside of the approved planning use can result in enforcement action, regardless of what the lease says. A vital point in your commercial lease is the permitted use clause. This defines what activities you are lawfully allowed to carry out at the property. This clause needs to align exactly what your business model and future plans are. Otherwise, you may find yourself unable to lawfully operate from your new property even after signing the lease. A vague or overly narrow description, such as office use or light industrial use, can create practical limitations. Whilst office use may typically cover training events and client meetings, and light industrial may allow for some storage or ancillary office use, issues can arise where your activities extend beyond what is typically expected within that use class. This can limit your ability to adapt the property, operate in accordance with your intended use, or prevent expansion of your business without further approval or variations to the lease. On the other hand, a broad use class can make the lease more attractive if you ever wanted to assign or sell your business, as it provides flexibility for future tenants or buyers to adapt the property for their desired use. However, this can inflate the rent on rent reviews, as the landlord may use a wider permitted use class to justify a higher rent, arguing that the property's value increases with the potential for various different uses. Our tip is to ensure that the permitted use is stated clearly and broadly enough in the lease to cover all of your intended activities and ancillary uses. In addition to what the lease allows, you must also consider planning laws. Even if the lease says that you can operate as a restaurant, you still need the correct planning permission from your local authority. As mentioned, the two systems operate independently. The lease governs your relationship with the landlord, whilst planning permission regulates how the property can be used in law. Planning use classes recently changed in 2020, as many use classes now fall under use class E, which covers commercial, business and service uses. However, some activities still fall outside of this and require separate approval. For instance, hot food takeaways, formerly use class 5A5, now require sui generis consent. Bars, pubs, nightclubs and medical clinics, and even some educational religious uses may also fall under these special categories. Do not rely on verbal assurances or assume prior use applies. Our tip is to consult with a planning specialist early on in the process. A planning refusal after signing a lease can leave you stuck with a property that you cannot lawfully use, while still being liable for rent and outgoings. The lease, title or historical planning conditions may also contain restrictions or covenants that go beyond planning, and your solicitor may need to spend time investigating this to explore the availability of indemnity insurance to cover the risk of any potential breaches. Sometimes restrictions can be embedded in historical title deeds referred to on the title or in historical planning documents, which may ban the sale of alcohol, prohibit noisy equipment or cooking on site, or impose limitations on the hours of operation. In summary, you will need to ensure that the permitted use in the lease matches your business plan. You will need to check whether there is planning permission required for your intended use, and your solicitor will need to review any additional restrictions that may apply and could impact how you trade. Never assume a property is suitable just because of how it appears to be. Always consult your solicitor and planning consultant to ensure that both the lease terms and planning permission align with your intended use before signing anything. Now moving on to rent reviews and rent increases. Rent reviews are a standard feature of commercial leases, especially for terms longer than 3 years. These clauses give the landlord a right to review and typically increase the rent at specified intervals, for example, commonly at 3 or 5 years. Most leases include what is known as an upward-only rent review, meaning that whilst the rent can go up, it cannot go down, even if market conditions worsen. So, how is the rent reviewed? There are 3 common mechanisms for rent reviews. Open market rent, where the rent is reviewed to reflect the current market rental value of the property at the review date. RPI or CPI index-linked increases. This is where the rent increases in line with inflation based on the retail prices index, RPI, or consumer prices index, CPI. This approach keeps the rent in line with economic inflation. However, it can lead to substantial rises for tenants if inflation is high. This is why a cap and collar are typically recommended for index-linked increases, which seek to limit the amount the rent can go up and down by, either by a percentage cap or specified amount. Thirdly, there are fixed increases. Stepped rent. The lease sets out a pre-agreed schedule of rent increases, for example, £25,000 in year 1, rising to £27,000 in year 3. This approach may be preferred for simplicity between the parties and for certainty. The heads of terms should stipulate whether there are any rent reviews and on what basis this is to be assessed. Your solicitor will confirm the lease accords with the terms agreed with the landlord from the outset. In short, rent reviews can significantly affect your future costs and cash flow. Understand the review mechanism clearly, negotiate fair terms up front, and obtain legal advice before signing the lease. Now we arrive at rights to assign and underlet. As your business grows and changes, you may not wish to stay at the same property for the duration of your lease. That is why it is vital to secure flexibility in your lease through clear rights to assign, also known as transfer, and underlet, known as subletting the property, or even part of it to someone else. These provisions act as an exit strategy or a way to manage overheads, particularly if you outgrow the business or the property and need to move, if you restructure or relocate your operations, if you want to sublet part of the property to generate extra income, or if you want to sell the business and need to transfer the lease to a new buyer. Many leases will allow assignment or underletting of the whole only, with the landlord's consent, not to be unreasonably withheld or delayed. However, landlords often include conditions that can make this harder in practice. Common landlord conditions to watch out for include requiring the tenant to remain liable on an assignment of a lease under an AGA, being an authorised guarantee agreement. This is where the outgoing tenant guarantees the obligations of the incoming tenant, such as for non-payment of rent. Whilst an AGA is fairly standard, the lease code now recommends that this should only be required where considered reasonable. Your solicitor will advise you on the wording of your lease and attempt to negotiate on your behalf. However, it is best to have this position clearly agreed from the outset. Another condition to watch out for is allowing underletting of the whole, but not underletting or subletting of part. This can limit your flexibility if you want to let out a proportion of the property for storage use or the back of an office. You should consider what rights you will need early on in order for this to be clearly set out in the heads of terms. Your solicitor will ensure that landlord consent cannot be unreasonably withheld or delayed. They will clarify that the landlord cannot impose additional unreasonable conditions. Try to avoid absolute prohibitions on assignments or underletting, and try to restrict the requirement to provide an AGA to circumstances where it is considered reasonable, as this is the position recommended by the lease code. It will strengthen your negotiation position or bargaining power if you get these agreed from the outset and clearly stated in the heads of terms. In summary, assignment and underletting rights provide vital flexibility for a growing and evolving business. Do not overlook these clauses, as they could be the key to scaling up, exiting, or surviving tough times. This brings us to a slightly different but equally important aspect: rights to make alterations. Most businesses will need to make some changes to a commercial property in order to operate effectively. Whether you're installing shelving, fitting out a kitchen, building partition walls, or meeting health and safety requirements, the ability to make alterations is often essential. To avoid any delay in the transaction, it is best to have as much information about the proposed fit-out works and any relevant plans readily available. Leases vary widely in how much freedom they give tenants to alter the property. In some cases, even internal minor alterations will require landlord's consent, and if this isn't clearly dealt with up front, it can lead to costly delays or disputes. The types of alterations to consider may include non-structural internal alterations, such as installing a new counter, or non-structural internal partitioning. Structural alterations may include the removal of walls, building extensions, or heavy equipment installation. And of course, there are sign and shop front signs to consider. Each category will be treated differently for the purposes of the lease. Internal non-structural works may be permitted without consent, whilst structural changes or external works will often require prior written approval and a formal license for alterations. Our tip is, when negotiating a lease, try to ensure, if possible, that internal non-structural alterations, such as installing a counter or internal non-structural partition walls or shelving, flooring do not require landlord consent. This gives you enhanced flexibility to adapt the space to your operational needs without incurring additional delays or additional legal costs that may be associated with a licence for alterations. If landlord consent is required for structural works or any other works, this consent must not be unreasonably withheld or delayed, and your solicitor will carefully review the wording of the lease. Always review your reinstatement obligations carefully. Most leases require tenants to return the property in its original state at the end of the term, so it's ready for a new tenant to begin their fit-out works. Where possible, negotiate to exclude reinstatement of any alterations that have enhanced the property's value. Improvements that benefit the landlord and reversion should not create unnecessary cost or liability for the outgoing tenant. In terms of a licence for alterations, it is important to understand the cost implications. Where landlord consent is required for alterations, as mentioned, this is typically formalised via a licence for alterations. If you anticipate needing one when negotiating a new lease, it's wise to agree up front that both parties bear their own legal costs, as this is generally considered the standard and fair position. However, if works are proposed at a later date and the licence is required after the lease has been signed, the landlord may seek to shift these costs, requiring that the tenant bears their legal costs associated with consent. This can add unexpected expenses, so it's best to plan ahead wherever possible. In summary, clarifying your rights to make alterations in the lease is essential to getting your business up and running on time and avoiding unexpected delays or costs. Think ahead about the changes you're likely to need and ensure that the lease provides you with the flexibility and scope to carry them out without unnecessary hurdles. To wrap up, I will be covering hidden costs or unanticipated costs. When budgeting for a commercial lease, it's easy to focus solely on the annual rent figure. However, there are numerous additional costs that can catch first-time tenants off guard if not planned for in advance. Failing to account for these can impact your cash flow and delay the ability to open or operate effectively. First up is stamp duty land tax, SDLT. Many people are not aware that SDLT is payable on the grant of a commercial lease, or potentially payable. This must be paid within 14 days of the lease's effective date, often the date of completion. Otherwise, penalties may apply. If you are paying VAT on the rent, then this will increase the SDLT payable, and this should be factored into your calculations. Our tip is to use the HMRC online calculator early on in your negotiations to estimate your SDLT liability and to avoid any surprises, although your solicitor will typically flag this to you early on in the transaction once they receive the heads of terms. Legal costs. While some tenants try to cut corners by reviewing leases themselves, this can be risky. A commercial lease is a complex legal document, and professional legal advice is highly recommended to spot and negotiate any unfavourable clauses, to ensure that the lease accurately reflects what is agreed during negotiations, and your solicitor will need to carry out a full due diligence exercise against the property. A lease is not merely a rental agreement that you can come out of at any time. You are tied into a commercial lease for the duration of the term, and you hold an interest in the property for the duration of the lease term, as well as inheriting any liability for any adverse matters that may burden the property. Our tip is that you should factor in your solicitor's legal costs for dealing with the lease, as well as their additional costs for dealing with additional documentation such as a license to alter or a rent deposit deed. Land registry registration costs. If your lease is being granted for a term exceeding 7 years, you are required to register your lease at the land registry. Registration fees are calculated on a sliding scale based on the lease's value. This typically ranges anywhere between £45 and £125, although these costs can be much higher. Your solicitor will deal with any post-completion formalities, including registration of the lease at the land registry. Search fees. Before committing to a lease, your solicitor will recommend that you undertake searches of the property to uncover any risks that could affect your business. These may include a local authority search, environmental searches, water and drainage searches, chancel repair and title or boundary checks. Search fees can range and depend on the property. However, they are recommended as they highlight issues that will need addressing or may need addressing prior to signing the lease. Surveys and condition reports. As Susan mentioned earlier on today, a full structural survey is highly recommended before entering into a lease. This helps you to identify any defects that may lead to costly repairs, such as through the service charge, assess whether the building is safe and fit for purpose, and will afford you with the opportunity to identify any issues or negotiate a schedule of condition to limit your repairing obligations. Our tip is, even if the landlord provides their own survey, you should consider commissioning your own for unbiased advice that you can rely on. This can protect you from thousands of pounds in unexpected costs or dilapidations later on. Other potential costs to watch out for includes business rates. This is a separate local tax payable to the council based on the property's rateable value. It's important to check whether your property qualifies or business qualifies for small business rates relief or any other exemptions. We have also touched on fitting out works and alterations. However, it's worth flagging this again in the context of costs, as you will need to ensure that you have factored in a realistic figure relating to the cost of any fit-out works and alterations, including the cost of any building contractors. You will need to work closely with your solicitor, accountant, surveyors, planning consultants and contractors to create a realistic estimate before signing the lease. To leave you with a final thought, many first-time tenants will underestimate the complexities of entering into a commercial lease. It's essential to account for all associated costs in your startup or expansion budget from the beginning. By considering the key points we've discussed today, you'll be better informed, more prepared to make confident, strategic decisions for your business.
Thank you. That brings us to the end of our presentation. So if anybody has any questions, we still have sort of 15 minutes in which we can take them. So if you'd like to, or Charlie can unmute you.
Have you unmuted? Oh, can I just say thank you so much, both of you, for that presentation. I mean, I'm not in the process of, a commercial lease, but I found you had some really great tips, and the key takeaways were really useful. I mean, our experience, we moved offices in April, the Chamber office, and I was surprised that we had to return the office back to as we first took over, fill in holes, but we even had to paint the floor because that was in the conditions. So I think knowing those details that you pointed out today is so important. I know people, if they want to unmute themselves, they can ask a question. Do you want them to put their hand up? Because I've got a couple of questions, once everybody else has asked them. So would you like them to put their hand up or just unmute themselves and ask the question?
Yeah, I think unmute should be fine. Yeah.
Okay, well, we'll open the floor. If anybody would like to ask Susan or Sibel a question, to go ahead.
Hi, I have a question, if I can go ahead. I just wanted to ask, if the landlord makes you to sign a document to exclude Landlord and Tenant Act 1954, do you have any kind of protection towards the end and any kind of guarantee that the landlord will extend the lease after, I don't know, 2 years or whatever the lease was for?
Sorry, no, if the security of tenure provisions are excluded, unless there's something in your lease which gives you a right of renewal, there's no guarantee. That's why it's important to try not to have it contracted out.
Okay, but I heard that there is something called Section 38A that needs to be served before the end of the end of tenancy agreement. What if that section is not served? Would that invalidate the exclusion of Landlord and Tenant Act 1954?
Is this related to a commercial tenancy or a
Yes,
residential?
commercial.
Okay. So does it say in your lease that they have to serve this notice?
Yes.
Okay. Then you may. It's not something I normally come across in leases, do you?
No,
Come across it?
all.
I mean, if you need advice on that specific point, please feel free to contact us afterwards. It's difficult to say without seeing the provision in your lease or the notice that they're intending on serving.
Okay, all right. I will contact you directly then. Thank you.
Is there any other questions?
Yeah, hi. I head up the commercial property department and work with Sibel and Susan very closely. You asked about something in your lease about Section 38, is that right? Who's that lady?
Sorry, yes, that's me. Yeah, I asked about Section 38A, yes.
And is that specifically in the lease? It's actually a clause in the lease about being able to serve notice under.
Yes,
Yes.
it says in the lease that it should be served.
Okay, so like Susan said, it's best that we actually see the lease, but sometimes it could be that the lease has got the right to request a new lease, but the landlord specifically states that they can serve a break notice based on one of the grounds of opposition, like redevelopment. So, you know, I've got a feeling this is probably something to do with a break clause that the landlord might have in the note in your lease.
No, there isn't such a thing. There isn't a break clause.
Okay. All right. Well, then, yes, it's best that you pass your lease to them to have a look at.
Okay. Yeah, I will do that. Thank you.
Okay.
Can I ask a question, please? Hello, Susan, Sibel, can I ask a question?
Yes, please. Yeah, sorry.
All right. Sorry, I was just saying I'm a complete novice, but you mentioned a planning consultant. So where would you find a planning consultant and how do they charge? Do they charge on a percentage of the lease or one-off fee? Is it a set cost? Because there's quite a lot of people that you need in this process that you highlighted.
Sure. I mean, we've got some recommended planning consultants that we can put forward if anybody did need any. But otherwise, I mean, it's usually through sort of word of mouth. You can sort of find them online. Sometimes they are specialists in particular areas. So it really does depend sort of what you're after. In terms of what they charge, again, I feel it probably will vary depending on the value of the matter, the sort of query that you have, and how complex the inquiry is really. I'd imagine sometimes they sort of charge by the hour is what I sort of know, but they'll sort of give a sort of estimate. Scoped fee is usually how it works, so you're sort of aware from the outset what it's likely to cost.
All right, well, thank you very much. And I think that's useful for, you know, for anybody else that's, you know, looking at this for the first time. I think it sounds like you definitely need a planning consultant, as well as obviously a good solicitor. I suppose you work together, don't you?
That's right, and that's particularly if there isn't formal planning permission in place for your intended use. I mean, sometimes it may be the case on the high street, for example, if somebody's taking over an existing property, but you've clearly got planning permission in place, then it may be the case that it's not required. It's just in situations where it's unclear whether there is formal planning permission in place is typically where we would be recommending that a client speaks with a planning specialist to check that there is sufficient planning in place.
Thank you. And my other question, unless anybody else wants to jump in, is when you talked about the landlord and you said about the upward only sort of rent reviews, it seems, I mean, is that something that a landlord would want to remove because it's only advantageous to them, isn't it? Because you said it's an option. I've just wondered, do most landlords have that in as a matter of course, or is that negotiable early on?
Most landlords, unless you negotiate something in the heads of terms, their solicitor will prepare the lease and it will have an upwards only rent review in it. The chances of negotiating very much depend on who's got the bargaining power at the time. If you've got a landlord that's desperate to let their property that's been empty for a while and they're covering business rates, they might be more flexible about things as opposed to someone who has quite a few offers and it has a property in a highly desirable area. So a lot of it comes down to the specifics and the bargaining power at the time.
Yeah, oh, thank you. Because I often wonder, as you said, when properties are, you know, unused, unlet for years, you think, well, why would they put the prices up? Because people can't afford the property in the first place in some cases. So, as you say, it's probably law of demand and the area that the property's in. Oh, thank you. So, has anybody else got any questions?